Hi, my name is Molly Hegarty, and I'm the Managing Director of Student Legal Services, here to talk to you about what happens when your landlord sells your rental property. When your landlord sells the rental property where you live to a new landlord or transfers management to another company, the new landlord takes the property subject to all rental agreements already in effect. Your original lease remains valid and does not terminate at the time of sale. The new landlord cannot simply increase the rent, evict you, or force you to sign a new lease. You should consult an attorney before you sign or agree to any new terms unless they are completely satisfactory to you. Don't let your landlord tell you that you have to sign a new lease now that they are the new owners. The new landlord should advise you in writing when you should start paying rent to them and how the rent should be paid. If you have not received this notice in writing from the new landlord, you should check in with both the old and the new landlord to find out when you should start making rent payments to the new landlord and where those rent payments should be made. The right to collect rent runs with the property, so your rental obligation to the new landlord typically will not begin until the property is actually sold and possession has transferred. What happens to security deposits, both of former tenants and current tenants, may depend on the terms of the sale. When rental property is sold, the security deposits for current tenants are often transferred to the new landlord. The new landlord will then be responsible for the return of your security deposit at the end of your lease term. However, if your old landlord does not turn over the security deposit to the new landlord, your old landlord is still responsible for returning the deposit to you. If you are not sure who has your deposit, you should send a notice of forwarding address to both your old and new landlords at the end of your lease agreement. If your security deposit is not returned, Ohio State students should schedule an appointment to speak with an attorney at Student Legal Services to discuss their security deposit and next steps. The one exception to the rule that your original lease remains valid and does not terminate at the time of the sale is if your lease agreement contains a statement that your lease will terminate if the property is sold. These types of clauses are sometimes included in lease agreements by landlords who are planning to sell the property during the term of the lease, or by real estate agencies that are temporarily renting the property until it can be sold. Ohio State students attending Columbus campus who have questions about the sale of their rental property or other legal matters should schedule an appointment to speak to a student legal services attorney at studentlegal.osu.edu. You can also call or text us with questions at 614-247-5853. Please note that this informational video refers to Ohio law and does not constitute specific legal advice. If you need legal advice, you should contact an attorney. The law may have changed since the date of the publication of this video in November 2022. And remember, keep in touch, follow us on social, and check out our YouTube channel.